More on this, let's now welcome a legal analyst, Elton Hart. Elton, a very good afternoon to you. So just listening to that report, give us a sense then on how these subpoena processes will likely unfold, especially when you consider the legalities and the threshold for Parliament to issue such subpoenas and, of course, the tight timelines that the ad hoc committee is being faced with.
Now, if one looks at the timelines that the committee is faced with, I think they might have issues on getting these witnesses before the committee in time so that they can actually finalize their work, because they have got a certain timeline in which they have to finish the work. And now this unwillingness of the witnesses to come and testify is aggravating that problem, especially Paul O'Sullivan, who's currently of the opinion that he can testify from Ireland. Brown Mogotsi, on the other hand, wants his own personal detail to actually make sure that he's safe. And looking at the bigger scheme of things, Parliament has the powers to subpoena anybody to come there in terms of the Constitution, to give evidence or provide documents. So Parliament is well within their rights, and I don't foresee how they can actually refuse this, because then they can start with contempt of Parliament proceedings against them, or they can actually just get warrants to actually bring them before Parliament. So they can choose in which boat they want to sail down to Parliament.
Yeah. So can a witness then refuse, to testify like we are seeing with these two? In fact, in the Mogotsi's case, as you're saying, he's got all the laundry list of issues that he wants done. And also, with Paul O'Sullivan saying that he can't come. Can they refuse to testify before Parliament, on, the grounds of ongoing investigations, national security, or even some saying, concerns around self-incrimination? And if they do testify under oath and the evidence seemingly contradicts prior statements that were made earlier on from other witnesses, what are they likely then to face?
I don't think that they've got an option to refuse. They can come like any of the other witnesses came before and say, I choose not to answer that question. But for them to blatantly refuse to attend the proceedings, that in itself becomes contempt of the proceedings itself. And for that, they can now face fines and penalties. And this is now, when you look at the Powers, Privileges and Immunities Act of Parliament, I think it's Act 4 of 2000 and something, if I'm not mistaken. So they can then face that penalty. So they can choose where they want to be. But outright refusal to appear before Parliament, I don't think that is something that they have at their disposal. They can come there and say, I'm not going to answer that. Or they can favor an answer, even if it's not accepted by the MPs, but they can say, this is my answer to that question that you're posing to me.
And talk to us about just, the legal safeguards. Earlier on, I mentioned self-incrimination. What legal safeguards do witnesses, not just, Brown Mogotsi and Paul O'Sullivan have, especially when we talk about, self-incrimination?
Obviously, one needs to look at these provisions of the Act, the Powers and Privileges and Immunities Act, but you have to read that act in line with the Constitution, because the Constitution is the empowering piece of legislation here, which is the supreme law of the country, that says Parliament can subpoena somebody to come and give evidence or produce documents to that effect. But in that same Constitution, in the Bill of Rights, you go at Section 35, and you know that Section 35 people has got certain rights, and you also go to Section 34, which speaks to federal rights. And then a witness or any other person that needs to appear before these ad hoc committees enjoys that protection that is captured in Section 35 and 34 of the Constitution, although they are supposed to appear before the committee if subpoenaed, but they still have that protection, which is self-incrimination is one of them. They can actually, that's where they would say, I would not want to answer that question because I'm not given maybe indemnity by the National Prosecuting Authority. If I say certain things that would incriminate myself, that I would not be prosecuted because I'm testifying here openly, honestly, and frankly, because there's no agreement between them and the NPA. So you cannot force them to answer questions or answer it like how you want them to say, because they have that right that's in the Bill of Rights.
And does that right also, extend to, for instance, when witnesses testify? I mean, we've seen this also at the Nhlanhla Commission, where witnesses, when they're answering, they say that they can't answer certain questions because it would compromise national security. Who ultimately then makes that call?
No, the thing is, like, when witnesses now come up with it will affect national security, that is now a security concern that is raised by them. And obviously they can only answer that if they have their line manager's approval, that they can actually sort of disseminate that type of information, especially if it's ongoing investigations, where they say, I cannot answer this in public, but maybe I can make it available. And the ad hoc committee or even the Nhlanhla Commission, they can actually ask these people to do in-camera disclosure of that information. So then it's not public, it's made in a certain setting where there's a protected environment where the information will not come out. So you can say, I'm not going to answer this on a public forum, but when we go, maybe if we use the English loosely, offline, I can actually provide and say exactly what it is, but that's given my line manager, who's maybe the provincial commissioner or a minister or a director or whatever the case may be, gives me the clearance and go ahead to say that I can disseminate that information with that. Otherwise, they have to take it up with that line manager. But that's just normal admin processes in there. And obviously, you can use the law to actually make a person provide the information and full disclosure. But obviously, to say that you'll escape prosecution if you are implicating yourself, knowing full well you've been warned about that, that's then on the witness. So they need to know their rights, and that's why they are given opportunity to consult with legal representatives before, during, and as they go along with their testimonies.
Elton Hart, thank you so much for your time and your analysis. I really do appreciate it. Legal expert Elton Hart there, of course, pressure mounting on a political fixer and Northwest businessman Brown Mogotsi, as well as private investigator Paul O'Sullivan.